In today's video, we're discussing how to sign a China manufacturing contract. It's fair to say that many of today's buyers still start working with a supplier in China or some other Asian countries without a valid manufacturing contract. Perhaps they have already dealt with them and everything has been fine so far, or maybe they come recommended or have Alibaba Gold supplier status. But the rule of thumb should be to plan ahead for the worst-case scenario, and relying on a foreign supplier's good graces is very far from that. Please note we are not lawyers. Any information provided in this video is cautiously informative, but we recommend contacting a lawyer who is familiar with China or Asian law to help you produce your manufacturing contract. Of course, if you are a small business owner and find this troublesome, Alibaba Trade Insurance is also a good choice. Okay, next, let's take a look at what is included in a manufacturing contract. There are roughly 3 elements to consider, although this will depend on your needs and the type of supplier you deal with, and we will go through them one by one. The first element is confidentiality agreement. China NDA or more comprehensive China NNN agreement. This will prevent the supplier from sharing your IP, using it to compete against you, or reaching out to your customers behind your back. Note here, keeping penalties sensible is important. The second element is product development agreement, the PDA. This is usually considered when you develop products with your supplier. This controls who will own the IP and outlines who financed what, etc. This will help you to move to new suppliers and take tooling and designs with you if needed. And the third element is manufacturing agreement, the MA. This agreement outlines what you want the supplier to commit to: product, specifications, quality standard, price, shipment date, etc. It takes away any ambiguity and makes your requirements 100% clear. I have detailed how to write a contract in the post linked below. If you are interested, you can use it as a reference. First of all, as a China sourcing company, it is very convenient for us to sign contracts online. If you do not have a company or business license in China, you may need to know 2 essential items to build into the terms and conditions of your contract. The first step is to make the contract enforceable. The second step is to ensure the contract provides for contract damages in a specific monetary amount for every act of breach. So let's talk about more details for each step. The first step, how to make the contract enforceable. There are 2 points here. The contract must be in Chinese or bilingual. There are many reasons for such an arrangement. First, to have any legal validity in China, you have to list the Chinese name of the suppliers. I'm talking about the Chinese name you see in their Chinese business license. Local authorities and courts only recognize registered Chinese names, so the English name or whatever they call themselves for marketing is not an official name. For example, you can't sue some company named Best Good Star Manufacturing in China, but you can sue 最好有限公司. If your key documents are in English, it complicates things a lot. For example, before the courts can make a decision, the English documents or supporting evidence will need to be translated into Chinese by a court-approved translator for the court's review. This can be expensive and very time-consuming. Plus, the defense can employ a stall tactic of fighting over the wording of the translation itself. It's much better to have your attorney structure the wording in advance in Chinese rather than hope the court's translation will be accurate. Be safe, use bilingual contracts or even just Chinese. If the supplier sees a document in Chinese, referring to Chinese law, drafted by a Chinese lawyer or business, and with an official red seal, then that is a different story. They know that you take IP protection very seriously indeed. Next, your contract should usually be written to be enforceable in a Chinese court with jurisdiction over the Chinese defendant. This means that Chinese law is the governing law, Chinese is the governing language, and exclusive jurisdiction is in a Chinese court with jurisdiction over the defendant. The fundamental reason for this China-focused approach is that in cases of infringement or circumvention, you must be able to move quickly against the Chinese defendant. Litigation must occur in a court with jurisdiction over the defendant, usually the city where the defendant is registered or where it normally conducts business. Any provision that provides for jurisdiction in another court will be ignored. For the second step, include penalty clauses in Chinese contracts. Contracts should have a reasonable penalty about what happens if the terms regarding exclusivity are broken. This penalty needs to be stated in the contract in advance, not only so the seller knows you are serious, but to make any potential future litigation go easy for you. The main value of putting a penalty in your contract is that it will motivate the supplier to comply with the terms so that actually you never have to enforce it. So how realistic litigation is if there are problems? Litigation in China is fairly straightforward and affordable compared to the US and Europe. Overseas companies can indeed win against local firms and individuals when they have the right lawyers and a solid case. It is important to find a local lawyer who understands the nuances of the legal system of the particular jurisdiction at the city or province level. Perhaps even more important is to be well prepared in advance. Lawsuits are quickly settled when you can show the court Chinese language contracts which included pre-agreed penalty clauses. If it's not enforceable in your supplier's country, litigation will be harder, and holding the supplier accountable in general will be affected. The dangers of being too trusting and not planning ahead for the worst-case scenario. Keep in mind that to litigate outside of China is for the most part meaningless. The vast majority of Chinese companies do not have any assets outside of China, and the court in China does not enforce foreign judgments. So it means that you actually get nothing, except a bill for wasted legal fees, even if you prevail in a court back home. So, if litigation is the only option to solve the dispute, a lawsuit should be filed in a Chinese court. What about PIs and POs? Are they still necessary? Once this contract is signed, you can issue POs, or you can have the supplier issue a pro forma invoice, the PI, and conform it. Actually, it doesn't really matter. Your protection comes from the contract. Make sure no PO or PI mentions that some of its terms cancel or replace the terms of the contract. That's the most important point to remember in the future. Okay, that's all we have for today. Thanks for watching this video.